So let's talk about our lesson for today. Today we're going to cover express conditions. We're going to do this in just one day, and I think that's quite doable because really what we're trying to understand today is, one, what are express conditions? What are they? How do we identify them? How do we distinguish between an express condition and a term, or a promise in a contract? So what's the difference? What's the distinction? And what's the consequence? What happens when a condition is not performed versus what happens when a promise is not performed? So that's really the whole lesson for today, and we're going to see that in a number of cases. We do have 4 cases to cover, but they're all teaching the same lesson. They're all showing examples of when courts will determine that something is a condition as opposed to a promise. And from that, in these cases, we can also see how the result will be different depending on whether or not we find we have a condition or a promise. So this is really part of contract interpretation because we are interpreting whether or not a set of words is one thing or another, what is the meaning of the contract. But we're beginning now to sort of push toward our next lesson in contract performance, because it turns out that whether or not a set of words is a term, a promise, or if it's a condition, this has an impact on what performance is required. And by understanding what performance is required, we can then say, was there complete performance? Was there substantial performance? Was there material breach? So we're kind of moving now toward performance, and as we'll see, this whole semester, things really blend together. And we're going to seamlessly, hopefully it'll feel seamless, we're going to seamlessly blend from our interpretation to our performance, because we have to know what a contract says to know whether or not the parties are doing what it requires. And then we're going to move from that into our last lesson for the semester about what happens when performance is not rendered. What damages are awarded? What remedies can be provided? And so we're transitioning through that now. So what is a condition? What is the definition of a condition? Well, Black's Law defines a condition as a future and uncertain event on which the existence or extent of an obligation or liability depends. Something that has not happened yet and may not happen. And whether it happens or not has a major impact on whether other duties are owed. The uncertainty of this act or event will either trigger, spring, create a duty, or negate, terminate, end a duty that exists to perform. And so these are sort of like, think of them like on and off switches. Whether or not the other aspects of a contract must be done are flicked on and off by the occurrence or non-occurrence of a condition. And so it's important to determine whether or not something is a condition or a promise, because if it's a condition, it doesn't have to happen. There's no breach for failure to perform a condition, but it excuses performance by the other party. So you may not have remedies yourself. So let me give you a few examples, and then we're going to see several more examples today, because your first job is to spot what is a condition, how to distinguish a condition from a promise. For example, we will see language. These are common phrases that will alert us that we are going to see a condition. We're trying to ascertain from the language what is the intention of the parties. And so language like subject to, contingent on, conditional on, provided that, these relate to that concept of something in the future that is not necessarily going to occur. It's going to either create or extinguish a duty. And so we often see this language. We don't have to, but what does language do? Why do we care about the language? Well, when we have a writing, the language helps us understand the intent of the parties. We're going to look at the writing first to determine what was the party's intentions. For example, a construction company's duty to perform can be subject to a favorable ruling at the meeting of the Planning Commission. You might want to build a building that is not to code, and so you have to go in front of a planning board and ask for a variance. Well, it might be a condition to your obligation to build that building that the zoning board approves the plans, that it approves the variance. Otherwise, that condition does not exist. It only springs into existence when the zoning board has said, okay, you can go ahead and build that 3-story building in that neighborhood. We're going to permit that variance. Under a securities purchase agreement, the parties' transfer obligations could be contingent on an expert's determination the purchase will generate favorable tax consequences. My goal in buying Microsoft stock from you is because you're going to save some tax because you have a lot of gains, and now you have a lot of losses, you want some gains, what have you. I want to purchase this instrument because it's going to achieve a certain result. And we agree that I'm going to buy it from you if, in fact, we can get a report that says it will do this. Right? Similar, right? So I don't have to buy that stock from you if that report does not say I'm going to get a tax benefit. It's contingent on that determination. A home buyer's duty to close on a purchase is conditional on the buyer being able to locate a 30-year mortgage at 6% interest with no points. Common condition, right? This would be a financing condition. Many contracts have a financing condition. An insurance company has a duty to pay the insured for a covered occurrence, provided that the insured files a claim within 60 days. Right? Unless you file within 60 days, you don't get paid for your flood insurance damage. Right? You had a flood yesterday, now you're going to file a claim with your flood insurance company. They have a condition that they only pay you if you notify them within 60 days. Okay, so a couple examples then. Let's take a look at a few of these. An insurer promises to pay for a new house if the house burns down. What is the promise? There is a promise and a condition in here. What part of this is a promise? Yeah, Cassandra. Payment for the new house. That's a promise. That's a duty. Right? That's a duty. And that's part of the contract. This is a contract, but there is a condition, in this case a condition precedent, that duty to pay for a new house does not arise unless something occurs. What is that condition, Derek?
The current home burning down.
The home has to burn down. Right? Unless that event occurs, there's no duty to pay. You have a contract with your fire insurance company. They don't just pay you. They pay you if your house burns down. That's a condition. That's a condition. And so the legal effect, if the house is not burned down, the insurer does not need to pay. All right, how about a contract that says client has to give notice within 10 days of the fire? Is the insurer's obligation to pay conditioned on timely notice? Is the notice provision a condition? Well, this is actually, it turns out, and we'll see this in our second case today, that at least in the case of International Rotterdam, sometimes courts construe things like this as something called promissory conditions, having elements of both a promise and a condition, where there is an obligation to do it. Right? How do courts determine that? Well, we're going to see some of those rules in International, where we have default rules, we have interpretive canons. We're going to look at the purpose of the contract. So you should be aware that something, just because something is a condition, does not mean it's not also a promise. It may create a duty and also be a duty. Right? So that's called a promissory condition. What if we don't want to have that happen? What if we want to draft it more carefully so that we are sure that that language is a condition? Right? Client must give notice to insurer within 10 days of fire, and then insurer must make a payment. Well, that could be either mutual promises or a condition and a promise. How could we write this better in order for that to be clearly a condition? What was some language we saw here that we can add? What are some of those bold words? Take a look. Maybe jot some notes down real quick. Right? How can we improve on that drafting to make it a condition? Any thoughts? Yeah, sure.
Insurer's payment is conditioned on whether the client must give notice within 10 days.
Yeah, it is contingent on, right? Does not have to be paid unless and until, right? It shall be a condition to the payment of any loss. Right? We want to add that specific language. Now, even if we have these quote-unquote magic words, courts might still find it's a promise or a promissory condition, but it really helps because the first thing courts will do is look at the language to determine the intent of the parties. So that's how we see if it's a condition. What happens if we have one? Well, now we have an agreement, but the duties under that agreement are not owed unless a condition occurs. And as I mentioned, conditional promises are that additional element where it might have both. The last thing you need to know before we jump into our case law then and look at some examples of this is that there are technically two types of conditions. there are conditions precedent. Conditions precedent trigger a duty. When a condition precedent occurs, a duty springs into existence. So there's no duty until the condition precedent occurs. Right? So our example there, the fire insurance. The insurer has no duty to pay until the house burns down. The house burning down is not just a condition, it's a condition precedent. On the other hand, we have conditions subsequent. It can terminate a duty. And it can be just phrasing, but a condition subsequent is one that terminates a duty, and so the duty exists until or unless the condition occurs. Okay, let's get into our case law a little bit here. Let's talk about our first case. Christian, have you had a chance to read this one?
Yep.
So just briefly, kind of what was this case about?
Okay, so Morrison, he wanted to buy a house. He bought houses and fixed them up and sold them to college students. So he was looking to buy a house from Bear. So when he was inspecting the house, he noticed there was a sticker on the furnace that said the furnace had a cracked heat exchanger.
Yeah, I have an image here of, by the way, I didn't know what a heat exchanger was. If you don't know what something is, use Google, right? I didn't know. It turns out that it helps warm the house, right? Exchanges heat. But apparently it can be cracked. So, I mean, it sounded valuable too. It looks like it's, this looked like it was expensive. So this expensive thing in a house is broken.
Yeah.
That might do what? It might decrease the value of the house.
Yeah. So Bear, he said that the furnace had been repaired, but he didn't say that the exchanger specifically was repaired. So Morrison then he made him an offer with the special condition that Bear had to give him a copy of the repair bill within 14 days of the offer. And then he ended up giving him the bill, but it didn't have anything about the heat exchanger being repaired on it.
Do you think that was what was intended? So the contract said within 14 days you'll give me an invoice, and then I give you an invoice and it says 0 on it. Was that your intention? Right, a blank form that said invoice on the top. So what was the matter with that argument? His argument was that I did comply with the condition, right? Well, although the contract said I want a receipt, the intention the court found was that receipt was going to show that this part was fixed. Right? That was the intention of the parties. So again, another evidence, another point here that the court is once again looking past the plain language to see the intention of the parties. Maybe they admitted parole evidence to do that. Right? The contract says one thing, but the parties clearly intended another, and so we have the admission of extrinsic evidence to understand that. So what did happen then? So he said he was going to provide this receipt. He did provide a receipt, and then did he go ahead and buy the house?
No, he didn't. He ended up suing them.
He sued him specifically for what? What did he want to get in that suit?
The heater fixed, or to have the price of the house reduced.
So this is critical. He was not suing to buy the house at full price. He was suing to buy the house at a lower price. Right? He was suing to buy the house at a lower price to account for the fact that what he was calling a promise, there's a promise to fix the heat exchanger. Let's say it costs $10,000 to fix a heat exchanger. If that is a promise and it is not fulfilled, what results? What happens if a promise is not fulfilled? Is a promise a duty that's owed to another party?
Yeah.
So if a promise is not fulfilled, what can you do in court? You can sue for damages, right? You can sue for damages on that. But what happens, on the other hand, if a condition is not satisfied? If this is not a promise but a condition, then what result?
It's just the duty was terminated. There was no breach. It was just.
So a duty was terminated. Which duty was terminated? What was the promise in this contract?
To close on the.
To sell the house, right? I will sell you my house, and there's a condition that I will buy it, and I hold a condition that says, but I don't have to. We have a contract. I have to sell you my house, Kelsey. You have to buy my house. Okay? That's a contract. But you're going to hold a condition, right? You can think of it and put it in your pocket, right? You're given an option, a privilege, right? What do you get? You have this condition. It says that I have to fix the heat exchanger or you don't have to buy the house. That was how a condition would operate. So what happens if I don't fix the heat exchanger? You don't have to buy the house. Now, do I have to sell the house?
Me?
Yes, do I have to sell? I didn't fix the heat exchanger. does that excuse my obligation to sell the house to you? What do you think, Juan? If I am selling a house to Kelsey, and she has a condition that says she doesn't have to buy the house unless the heat exchanger is fixed, even if that's a condition, if I don't fix the heat exchanger, does that excuse my performance? Does that mean that since I didn't fix the heat exchanger, I don't have to sell the house?
That would mean that the condition, yeah, you wouldn't have to sell the house because it's not a promise, it's a condition.
So let's think about the result of that. So Melanie, what's the problem with that result?
Well,
Who controls the heat exchanger?
the person owning the house.
I control it, right? So let's say I offer to sell the house to Kelsey for $100,000, and there's a condition that I'll fix the heat exchanger. It's her condition, right? She wants the heat exchanger fixed, and so her obligation to pay me $100,000 does not occur unless or until the heat exchanger is fixed, and I can show it. Now, I get another offer from Melanie to buy the house for $120,000, and she doesn't care about the heat exchanger. So, what do I want to do? I would rather earn $30,000 more by selling it to Melanie, right? So, if it were the case that I simply could not fix the heat exchanger, and in that way not have an obligation, do you see how that creates a perverse incentive? So, is that the case? Is that right? If I don't fix the heat exchanger, if I don't make any efforts, does that mean that I don't have to sell the house? John?
Because the person whose contingency it is can waive it.
Right. You can think of the contingencies as being almost like an asset or like property. Someone holds that contingency. It is theirs to use. It is theirs to protect them. It is Kelsey's contingency. There are two problems with me not fixing the heat exchanger. One is that I have, as Isabella pointed out, a duty to bring about that condition in good faith. And there's a perverse incentive here that if I could get out of my obligations by my own failure to perform, that's not what the contract intended. So a condition will only preclude or will only be advantageous to the person who's holding it. Right? In this case, this is Kelsey's condition. So in fact, if I don't fix the heat exchanger, what can Kelsey do? Can you? Can you sue for specific performance? Yeah. What do you think, Christian? If I don't, in this case here, the heat exchanger wasn't fixed. The heat exchanger wasn't fixed. So what options does the buyer have at this point? He wanted to sue for the value of the heat exchanger. To not close. The buyer has the option to not close, or what's the buyer's alternative?
Accept it as it.
Accept it as it is. The buyer can waive the condition. It's your condition, Kelsey. You might decide that now that Melanie's in this, you know the house is really worth $120. You were getting it for $100, and you're going to have to put $10 into it. So you're getting the house for a $10,000 discount. You wanted it for a $20,000 discount, but it's still worth buying to you. So even though I didn't fix the heat exchanger, you can still buy the house. It's your condition. You now can either waive the condition and buy the house, or you can refuse to buy the house because you don't owe me that duty. You don't have to pay me that duty. So, to put it another way, what happens if a promise is not satisfied here? If this were a promise, what happens if I don't fix the heat exchanger?
Then you can sue for breach of contract.
I could be sued for breach of contract for the amount of that heat exchanger. She can buy the house, and moreover, if it is a mutual promise, and I don't fix the heat exchanger, Kelsey, do you have to buy the house anyway? If this is a promise and not a condition, if I promise to fix the heat exchanger and you promise to buy the house, and I don't fix the heat exchanger, do you have to buy the house? If this is a promise, is my failure to perform my promise, does that excuse her promise? No. It has to be a condition to excuse her promise. If I promise to fix the heat exchanger and you promise to buy the house, you have to buy the house whether I fix the heat exchanger or not. That's the difference between a promise and a condition. If it's a promise, I have to do it and you have to do it. Whether or not I do it does not affect your obligations. These are mutual and independent promises. So whether or not I fix the heat exchanger, but as Christian pointed out, if I don't fix the heat exchanger, Kelsey has to buy the house and then she can sue me for the value of the heat exchanger. Why? She fulfilled her duty. Her duty was to buy the house for $100,000. I breached mine. I was supposed to fix the heat exchanger. I'm in breach, she can sue me for those damages. On the other hand, if her promise to buy the house is contingent on my duty to fix the heat exchanger, if it is a condition precedent to her duty, and I do not perform my condition, now, Kelsey, do you have to buy the house? If it's a condition, that's what a condition is. It gives you the option not to buy the house, or you can buy the house. If you buy the house, can you sue me? One, if I'm selling the house and I did not fix the heat exchanger, we're now saying that we're going to interpret this as a condition, thinking about the results of that, the consequence of that determination. She's now paid me $100,000 for a house with a broken heat exchanger because she waived her condition. Can she sue me?
No, because you took it as is.
No, because a condition does not create a duty. A condition does not create an independent duty. It's not a promise. I didn't have to do it, but if I didn't do it, I did have an obligation to make reasonable efforts to bring it about. Otherwise, I breached my duty of good faith and fair dealing under our contract, and we are in a contract. Yeah, Jacob.
If you're making that promise, is it implied that you're taking the house as is? Because it would seem like that's not what's bargained for, a house with a broken heat exchanger. So if you're buying the house like that.
So the analysis first will go, is this a promise or a condition? If it is a condition, then we look at whether or not she waived the condition. If she waived the condition, then I have a duty to sell it, she has a duty to buy it, but she cannot sue me for breach. You cannot breach a waived condition. She's essentially taken that condition. It's almost like she retroactively took that condition out of the contract. She has two choices. She could also, by the way, do what? She could negotiate for a lower price. She could say, well, I'm not going to pay you $100,000 and I don't have to. I don't have an obligation to do that because that condition was not performed. A condition precedent did not occur. Now, in this case that I mentioned, I could sell it to Melanie for $120, so that's not going to work. But if there's no other buyers, if Melanie offered me $80, then maybe Kelsey can get me to drop the price to $90,000, right? We could have a new contract. Don't fix the heat exchanger, forget the heat exchanger, just charge me $10,000 less. But we'd have to negotiate for that separately. If she simply waives her condition, then that shows that she didn't value it as much as she valued purchasing the house. So, to put it yet another way, if a promise is not performed, right? Well, think about it this way. We could either structure these as mutual and independent promises. I have to fix the heat exchanger, you have to buy the house, and those almost operate in two different worlds. They might be written in the same contract, but those are mutual and independent. Regardless of what I do, you have to perform your obligation. Regardless of what you do, I have to perform my obligation. That would also imply I have to fix the heat exchanger, even if you don't pay for the house. But then I can sue you, right? I can sue you for failure to perform. I can sue you for, again, the entire amount. Right? On the other hand, if this is a condition, now what if it's a promissory condition? What if this is not a condition or a promise alone, but a promissory condition? What if there's a promissory condition that I need to fix the heat exchanger, and Kelsey then has an obligation to buy the house? Now what result? If I don't fix the heat exchanger, can Kelsey waive that promissory condition? Can she still buy the house? Yes, she can. She can still buy the house, but now, since it was a promise, she can sue me for failing to fix the heat exchanger. Right? That's the distinction between a promise, a condition, and a promissory condition. A promise I owe regardless of what she does. It doesn't have any impact on her duty to me, and her promise to me is mutual and independent. She owes it to me regardless of what I do. A condition, on the other hand, will either create or extinguish her duty to perform. But she can't sue me independently for it. It only is a switch. It only turns on and off her operation. It only turns on and off her obligation to perform. And then if it's a promissory condition, it is both an obligation and a switch. In that if I don't do it, she doesn't have to close, but if she does close, she can sue me for failure to perform on my promise, because now I am in breach, because it was both a promise and a condition. Let's see if I have any more comments on that. How could this condition be waived? What would that process be like? right? How would you go ahead and waive? So you have a condition. How would you waive it? Well, one could be waiving it implicitly by simply buying the house. More oftentimes, there'll be a document that says we're agreeing to waive the condition. And we're going to talk about waiver and excuse next Wednesday. So, what does the court decide, Christian? What does the court say this is? Was this a condition, a promise, or a promissory condition to fix the heat exchanger?
It was a condition.
It was a condition. The court held that the promise to fix the heat exchanger was really a condition. It wasn't an independent promise. Why did the court find that? What were the facts? This is almost always a fact-specific inquiry. What are the specific facts here that lead us to find this is a condition? Yeah, Mark. Yeah, that certainly helps. There's a category, special conditions on the contract, and it said special conditions, number 1, fix the heat exchanger. So, first thing we look at is the contract. Read the contract. Contracts class, read the contract. And what does it say? It says a condition. Now, that's not dispositive. It's not the only fact we look at. Is that commercially reasonable? Is the result of this being a condition commercially reasonable? Does that make sense? Does that make sense, Kelsey? I mean, are you handy? Anyone here not very handy? Tyler, you're not very handy, right? And so you don't want to buy a house with a cracked heat exchanger because you don't know anything about fixing it. So, right. You want to buy a house that works properly right off the bat. You're not buying the beater and fixing it up. So, do you think it's commercially reasonable that you don't have to buy that house if it doesn't work?
Yeah, I hope so.
Hope so. That's what you might have intended, right? So it could certainly be commercially reasonable that a buyer who is not in the business of fixing heat exchangers would want a house with a fully functional heat exchanger, does not want to put that effort into it. So the phrasing is only part of the analysis. It also has to do with what makes sense under the contract. All right. Any questions about Morrison? All right, let's take a look then at, John, please.
So, the case really didn't say that the owner said that he repaired, right? It was very carefully phrased that I will give you a receipt showing that it's repaired. Now, the implication is that it was the thing that was asked about. Suppose he would have explicitly said, yes, I fixed the heat exchanger. The buyer said approve it, entered into the contract. Now it's a condition. However, it's also based on his misrepresentation of what was done. Would this have come out any different then?
You mean if the guy lied and said that he fixed the heat exchanger and really didn't? Oh, sure, yeah. If he's committing fraud and misrepresentation and didn't actually perform, then he is certainly going to be liable for that.
But the thing is that the buyer still put the contingent on show me the receipt. Now, if the receipt doesn't support it, does it come down on the contingent side?
Sure.
Or does it come down on...
Well, let's talk a little bit more about the receipt. So Christian was beginning to talk about this, and we moved on to something else. Let's go back to that. What did the contract say? Show me a receipt. Show me a receipt. And it didn't even, I don't know, did the receipt even have to say that it was fixed? It was just showing that there was work done, basically.
Now, it was supposed to say that the heat exchanger was fixed. That's what the buyer was asking for.
Yeah.
But the seller is just saying, yeah, I fixed the furnace. Doesn't say what he fixed.
Yeah, he didn't, so you're saying he didn't really comply with it. So, your thoughts.
The court said that the agent, Mr. Kim Penza, had told him specifically that the exchanger was fixed. So he said, okay, fill out the purchase agreement, and then put a specific condition that said, upon receipt that says that it was fixed, then we'll follow through. And because that condition could never be met because it never existed, the courts were kind of decide whether it's going to be a counter offer or a contract that just never existed because it could never meet the criteria could never be met. That's what the dispute came down to.
I thought what John was asking though was, if you commit like fraud or you obfuscate, then what result? The condition didn't occur, but you said that it did, and then you apparently waived your condition under the mistake or mistaken idea that it was performed. You didn't actually mean to waive the condition, but it was not actually performed. Was that where you were going with that?
Buyer says furnace looks cracked.
Right.
Seller says I fixed the crack, as opposed to I just repaired the furnace, which means two different things. Buyer then says prove it.
Mm-hmm.
Okay. Now at that point, would the court turn around and come down on specific performance? Because in order to create a contract.
No, the court. Well, first off, they won't come down on specific performance because damages, a money remedy could solve the problem. But I think the fundamental thing here is that we are getting caught up a little bit in what the contract said, and what the court did here, as I point out, was they looked beyond the mere words to try to ascertain what the parties actually intended. And right, the parties did not intend that I have a receipt showing something about the furnace. This was what the contract was for. And the condition was to have this heat exchanger fixed because Tyler doesn't want to buy out the cracked heat exchanger. He doesn't know anything about this. That was his intention. There was a little bit of maybe mistake or confusion. It wasn't written as perfectly as it could have been. But the court sees through that and says, no, this was a contract. There was offer. There was acceptance. There was consideration. We're now going to evaluate what that contract said, and we're going to interpret it to say that the heat exchanger needed to be fixed as a condition. All right, we have three more cases. Let me move on to international. And this case was about something called pockets of rice. I actually don't know what a pocket of rice is. It's some amount of rice, I guess. Doesn't really matter. They're selling some rice. So, Juan, what happened in this case?
Sure. So we have next quarter and buyer's rice, which is Internatio Rotterdam, and who's the plaintiff, and also there is a processor and seller of rice who is River Brand Rice Mills, who's the defendant in this case. They established their agreement and contract in July of 1952, where the agreement said that they wanted to sell 95,600 pockets of rice.
Okay, so is that a contract? I want to buy 95,000 pockets of rice, and you want to sell 95,000 pockets of rice. Does that sound like elements of a contract, at least?
Yeah.
So that was the promise. The promise was to buy and sell 95,600 rice pockets. So we have to always, there always needs to be a promise, of course. You can't, if you just have a condition and no promise attached, it's not a contract. We have to have some kind of obligation. So we need to find the promise. And the promise was, I will pay for rice, you will sell me rice. Was there a condition attached to that, though? Is there anything that I have to do or you have to do for that requirement to buy and sell rice to occur?
Yeah, it said that the contract required Internatio Rotterdam to obtain financing that guaranteed payment to River Brand once it presented doc receipts that evidence the delivery.
So financing, but there was another provision here that had to do with time, right? Time is of the essence in many contracts. So there's a really important provision about time here, Christian. What was the time-based provision?
Yeah, it also talked about the shipment dates that in December of 1952 it would have to be shipped with, or you would have to, with 2 weeks call from the buyer. So basically they would have to ship it within those 2 weeks
So
of December.
it turns out that rice prices change. And you don't know when you're going to need all this rice. It's a lot of rice. And if someone showed up at your door with 95,600 pockets of rice, well, if you have a flooded basement, you actually might have something to do with it. It could soak up all that water, right, Mary Beth? Or you might have nowhere to put the rice, right? You want to receive that shipment of rice at a time that you can use it, right? When your basement is dry, where you have a place to put it, where you have an area for it. So you might not call for that shipment until you're ready to receive it. But you might also play some games here because the price of rice can change. And if this is seen as a condition and you don't perform it, what occurs? If you don't perform your condition, the other party doesn't have to ship the rice. So there was some issue about timing that really mattered because it turns out price really mattered. Shipping rice is kind of complicated. The logistics were complicated. And so there was a notice provision that said that the notice had to essentially be given by December 17th. It was a little complicated how that all worked out. Basically, they needed to have it delivered by the end of the year because of the way that the pricing structure works. The intention, the court found, right, was that the seller wanted to have that rice delivered and paid for by the end of, what year was it again? 1952? By the end of 1952. Okay, wanted that rice. So, and it was a 2-week shipping process. So if you simply subtract 2 weeks from December 31st, you get to December 17th. So it was a little complicated how that operated, but essentially there was a provision that said the buyer has to give notice by December 17th. Was that a condition, a promise, or a conditional promise?
I think the court leader says it was a condition precedent,
So it was a condition precedent, and how so?
because the duty wouldn't be triggered until the condition was set, which was basically the notice of having to ship the goods.
Christian, why does this have to be at least a condition, right? Why does notice and stating where you want the rice delivered have to be a condition for delivery?
Because they have to know that to be able to.
You have to know that. How can you ship rice when you don't know where you're shipping it to? Right? It has to be a condition. The obligation for me to ship rice to you must be contingent on the provision that says, tell me where to ship it to. What am I supposed to ship it to? Where? Right? To your basement. Not your basement. Right? So just by reading the contract, right, it seems pretty clear that this notice provision has to be at least a condition. My obligation to ship rice cannot occur unless you tell me where to ship it to. But was it more than that? Was it more than a condition? Was it also a promise? I mean, what was the contract for? Was the intention of this contract that if I don't provide notice to you, you don't get to sell me the rice? What's the problem with that? If I don't give notice, you don't sell me the rice. Now we have a problem with the contract. Madison, what's the problem with this contract now?
You could probably try and inflate the price. So if I don't give notice because the price of rice increases, then I get out of paying that.
Well, I'm the buyer, so I probably would wait for it to decrease, right? But exactly, right? As Madison pointed out, now is that the intention? December rolls around, rice prices have gone down $1 a packet or whatever. So what am I going to do? I'm going to simply not give notice. I'm not going to give notice, and I'm not going to have any obligations to buy the rice. That's a problem. That's a problem because that means that, is that what the contract intended? Do you think that the seller intended to give the buyer an option to get out of it at any time if the price went down? Of course not. Of course not. And in fact, likewise, was there a mutual obligation? Did the seller have an obligation to sell this rice at that price if the price went up? Yes, it did, provided that notice occurred. Provided the notice occurred. So, was this a condition, a promise, or a promissory condition? What do you think, Serena?
I think that it was
A condition precedent. So if it doesn't occur, there's no liability. So the buyer would not have liability. Anyone have a different opinion? Anyone see liability for the buyer if they don't give notice?
I think it's a promissory condition.
Yeah, it seems like a promissory. Why is it a promissory condition, not just a condition? What makes this a promissory condition that creates an obligation on the buyer? Amanda.
Because if not, like we were just saying, if it was a condition, it would allow the buyer to basically walk away.
You look at the result, right? The result. We were not giving the buyer did not buy an option to purchase rice. The buyer did not pay $1,000 for the option to pay $100,000 in the future, whether or not the price went up. That's called an option. Options usually aren't free. You know, I might say, hey, for $100, I'll give you the option of buying my car for $10,000 next month. So you give me $100, and now you have an option contract. Was this an option contract? Was that the intention? No, this was a contract. This was a contract for the purchase and sale of rice, but it had a condition because the seller could not ship the rice if it didn't know where to ship it to. So the failure to give notice has two problems. One is it probably, even if this were not a promissory condition, as the court does call it, we have a duty of good faith and fair dealing to bring about this. And so the first issue is that if I simply don't give notice because the price I had offered to buy that rice for $3 a pocket, the price of rice has gone down to $2 a pocket, and so I don't give notice because I want to pay less for rice. I'm in a relationship with my contract party, and now I'm going behind their back. I'm trying to get a better deal. I'm scheming, right? And that violates the duty of good faith and fair dealing. And so the court here finds that this was a promissory condition. So what are the consequences of a promissory condition, Juan?
The consequences are that basically that it becomes terminated if the seller doesn't decide to sell it. It's like you said, it either goes one way or the other. If you accept the contract, then
Well, you're still focusing on only the condition part of it. Now, we've determined, our first step is, what is this? Is it a promise? Is it a condition or a promissory condition? Right? We found it's a promissory condition. What you've described is how a condition operates. What is different between a condition and a promissory condition?
was that you could accept the offer and also sue for the difference.
And also sue for the difference, because you can waive and sue for the difference, right? And so there is an obligation. And in fact, if there's an obligation on the buyer they failed to meet, the seller can sue. Why do you think the seller in this case didn't sue, though? Any ideas why the seller didn't sue? What would the seller sue for? The seller would sue for damages. Right? What are damages? Damages would be the amount that they would have, in this case, as a little sneak preview, it would be an expectation damages, what they would have expected to receive under the contract, the value of the rice at this price. So if the price of rice has gone up, the seller can sell the same rice for more money. If I was going to sell 90,000 pockets of rice to Madison for $2, she doesn't perform her condition, and so I'm excused from my obligation, and she didn't perform her promise. So I could sue her for 90,000 times $2, right? And, or, minus the value of the rice, whatever the profit on that rice is. But I sell it to Benjamin instead for $3 a pocket. Now, how much am I harmed? How much am I harmed by Madison's failure? I'm not harmed at all. I'm not harmed at all. The reason why, although there was an obligation, Madison failed to meet her promise. She is in breach. She is liable for a suit. But that suit would be for damages. The damages are the difference between what the rice cost me and what I would sell it for. And now I've sold it for even more money. I made a profit because of this. I don't want to sue. I'm not going to get anything from that lawsuit because there are no damages to the seller here. But if I sold it to Benjamin for $1, right, instead of $2, now I've lost $90,000. Now I can sue Madison because she failed to meet her promise. I was harmed as a result. I lost out of $1 times 90,000 pockets of profit. And I can sue her for those damages. Mike?
If it cost you money, like whether it be the labor of having your employees go out and find another buyer, or you had to store the rice a few days longer or something like that, can you then sue for those damages?
Yes. I can also sue for my cost to cover.
Okay, so
and we'll talk about that in damages.
Even if there's not a deficit between,
there has to be a deficit. It has to be a net deficit. But if I sell it to, let's say that Madison doesn't buy my rice, and I sell it to Ben for $2 instead. But I held the rice on my property for 2 extra weeks, and that cost me 3 additional sales, right? As a result of that, although I got the same price in the end, I can sue her for those costs that I incurred as a result of her breach. We'll cover that in Chapter 9, in damages. But yes, I can sue for my cost to cover. Yes?
For promissory conditions, are the result or the consequences one to sue for damages of breach, that also are you afforded to rescind the contract or stop the contract because of the condition?
So if the condition, in this case, the condition is held by the seller, right? And Madison is the buyer. Madison has not performed her promissory condition. I can waive and perform anyway. First off, since a condition did not occur, my obligation is extinguished. So I don't have to sell the rice to Madison. However, I can waive her notice and say, I'm shipping you the rice anyway. Now that's an issue because it may show up where she doesn't want it to be, but you can change the facts a little bit. So I could waive the condition and then sue her for however much that cost me. She didn't give me notice on the 17th. She gave me notice on the 18th instead. It was a promise. And every day that I hold that rice, it costs me $300. I could sue her for the $300 because the result of her breach of that promise cost me $300, even though I waived the condition, because it was both a condition and a promise. It has the features of both. Does that answer your question?
But then can you just, I think they stopped the contract, the buyer stopped the contract in the end, they didn't want to.
If I don't sell, right, like in this example, right, again, I don't sell it to Madison. I don't waive the condition. I simply do not perform, which is exactly what happened here. I can then sue her for however much I'm harmed by the result of her failure to perform that promise. But in this case, there was no harm. So I can either waive and sue her for the difference between what I would have gotten if she performed. If it's a promise, I can sue her for the difference between what I should have gotten and what I did get. In this case, I got more than I expected, so that is nothing. There's no suit against Madison here. I sold it to Ben for $3. If I sold it to Ben for less, or if I waived the condition, I sold it to Madison under more difficult conditions, I would sue her for that difference because she failed to perform her promise. And that's distinguishable. If this were only a condition and not a promise, I could either not perform or waive, but not sue her. Let's talk about another case here, Vesko versus Hodges Development Corporation. Christian, if I can bounce back to you here. So what happened in this case?
Renovest wanted to buy an apartment complex from Hodges. He put down a $65,000 deposit, and there were two conditions precedent. The first one was that Renovest would do an inspection within 14 business days, and if it was not satisfactory, then he could void the contract. And the second one was that if Renovest couldn't get financing within 45 days, then he could void the contract.
So I want to just step back because I want to do the analysis. So you answered the question of was this a condition or a promise, but we should always take the analytical approach. So we start by saying what are the provisions in the contract that were at issue, and the two provisions here that were at issue were about a duty to notifying the buyer that a building inspection was unsatisfactory, and notifying the buyer that financing could not be obtained. So now that we've isolated the provisions at issue, and you were right, they are in fact conditions precedent, but why are these conditions precedent? Why is it a inspection and financing contingency? Yeah, Rena. So that's again, that's focusing on the result, right? The holding. But we need in our process, we need to do the analytical step of saying why the language should be interpreted as a condition as opposed to as a promise. Why was it a condition and not a promise to provide notification of inspection? Right? Why is that how the court finds? Yeah.
Well, the party intended to have the inspection completely done and have the right financing for the obligation to have the inspection.
Always a good instinct to go to the intent of the parties, right? Right? The intent of the parties was that this should be a condition. But how do we evidence that this was the intent of the parties? What is the evidence that the intention of the parties was that this was a condition and not a promise? The language of the contract, right? We start with the language of the contract, right? It said it was a condition. And in similar contracts, in contracts like this, in contracts for sale of homes, this is extremely common, right? So we look both, if you want to call it subjective and objective, it's kind of like that, subjectively, or at least individually. In this case, this language said effectively that it was a condition. When you read the contract, when you interpret the contract, Chapter 7 is what we're doing, when you interpret the language of the contract, it says that it's a condition. Also, when you look at contracts that are similar, and now you have a case that you can point to, if you were given something that you needed an analogy, you could say that in Renovest, the court found that contracts for sales of homes, these type of provisions are usually contingencies. It's what the parties intended, and it's what is commercially reasonable. Right? It makes sense. It comports with our understanding of how these contracts operate. We need to always do that step first. The court did kind of jump to the conclusion there, but we need to determine whether or not we have a condition or not. Okay, so we have a condition precedent. So what is the result of that? Do conditions, sorry, I should go on. What then happened? Was the condition performed? Was notice of inspection given? Was notice of failure to obtain financing given?
No.
No, it wasn't. What happened? What happened instead? Juan?
Well, I know on the financing side, they attempted to seek out four banks, and two of them were interested, but they didn't try their absolute best to obtain those loans.
Right. So what is that? What then, would we read into this? We have a condition that says you have to notify the buyer of a failure to get financing within 45 days. Did they actually send a notice within 45 days?
They did not.
It wasn't timely, right? And so one thing we learned from this is we need to strictly comply with express provisions. Time is always of the essence in a express condition. If it has a time period, you have to comply with the time period. What was the other problem with their fulfillment of this condition or using this condition? They failed to make reasonable efforts. Right? They failed to make reasonable efforts. Why? Because the duty of good faith and fair dealing creates an obligation on the part of the person holding the contingency to make reasonable efforts to bring it into existence. Right, so again, the big lessons here, this was a smaller case, right, but it did have a couple of key rules that we need to draw out, right? One rule that comes from this case is that on page 850, it says, a rule of strict compliance traditionally applies to performance of an express condition. This is the case you cite to where notice was given 61 days and it said 60. Right? This is the case that says you have to comply with express conditions strictly. And the facts here are helpful because it has to do with time. 61 days is not 60 days. It's not within 60 days. And so while it may seem reasonable, right, we have a rule here. Courts will interpret express conditions this way. And by the way, we're going to talk about implied conditions next. We don't have the same rule for implied conditions. Michael.
Did you ever get like a one-day exception if the last day fell on a holiday or something? Like, is that factored in here? Like, say it was on Monday and it was Memorial Day.
So it turns out that days are not always days, right? When you say you have 10 days, do you have 10 calendar days? Do you have 10 business days? If it's calendar days, then if it falls on a holiday, it probably doesn't matter. If it's business days, then you're excused. And if the contract doesn't say, now we have an ambiguity, right? And so if you're trying to count days, and by the way, this will happen more often if you take civil procedure really seriously, right? There are all kind of days and times in civil procedure, right? And so how do you count days in civil procedure? When does that start? It's a question of interpretation. In that case, it's statutory interpretation or rules interpretation, but we apply the same canons, the same reasoning. What you learned here is applicable to every course that you take when you have to interpret a rule or a statute or a contract, right? So how do you count days? Well, if it's not clear, the court will have to say, well, days means days. For the most part, courts will say 7 days means 7 days. It doesn't mean 7 business days. However, the court might look at what? What could the court look at to determine whether days means business days or calendar days? Shay, do you have any ideas? Yeah, the contract just says days. And just like chicken, days might be ambiguous, latently ambiguous. Well, usage of trade, right? Usage of trade, course of performance, course of dealing. You'd look at course of performance, course of dealing, and usage of trade if this were a contract for the sale of goods, right? You would follow the UCC in that capacity. And that may answer whether or not days is business days or calendar days. But if it's calendar days and you didn't perform, that's what I mean. Strict performance is strict performance, right? You didn't perform. 61 days is not 60 days. And you should have calculated that. You should have looked at the calendar before and saw that it was Christmas morning, and you couldn't perform on that day, or you should have performed 2 days earlier. Yeah.
Wouldn't the court also consider what the thing was she was supposed to do? Like if it said the buyer shall deposit at the bank $100,000.
Absolutely. Right. Yes.
60 a day fell on Sunday.
On a Sunday, banks aren't open, right? So that wouldn't be a reasonable construction, right? So courts will look at other facts and circumstances as well. If course of performance, course of dealing, and usage of trade do not answer the question, right? Courts are entitled to look at all sorts of extrinsic evidence, and courts will admit extrinsic evidence to resolve an ambiguity, right? So things like the fact that banks aren't open would also kind of go toward usage of trade, that when you say 60 days in this industry, you mean the next day after that when a bank is open, or the industry practice might be the day before the bank is open, right? So it really depends on the industry and the practice. So, rule of strict performance traditionally applies to express conditions, so cite Rena for that one. the contract, why do we interpret something as a condition precedent? Well, you have to do that analytical step, and as Rena pointed out, look at page 852. It was in a section called conditions precedent. I know this sounds obvious, but you need to actually state that. You need to state the obvious. Why? Because you know what? It's not dispositive. Just because something is written in a condition precedent section does not mean every time, every case, and even if it were, you still need to say that. But it's not the rule. It's very good evidence. Just like a merger clause is very good evidence of an integration, there are facts. We saw a case. There was a merger clause. We did not have a complete integration. It happens. You could have something written in the conditions precedent section, and it could still be a conditional promise, or even maybe not a condition, right? Even though it was written that way because it didn't comport. We also might look at the function, what the parties would probably want. We could look at what the parties actually wanted. We could look at the subjective intention of the parties. We could look at the objectively reasonable intention of the parties. And we also are going to look at the commercial circumstances, right? And so here, it's typical that requiring notification by a certain day is a classic use of conditions. We need to go through that analytical process. When we see something that may be a condition, do not just jump and say it's a condition, but go through that process. Conditions can be waived, but you have to then demonstrate facts showing waiver. And so you can see a little bit on that on 851 as well. All right, so that's a helpful case. It was a short case, but had a lot in it. So let's take a look at just one last case here. And this one's kind of interesting because, as I said, just because something is written a certain way doesn't mean it will necessarily be ruled that way by a court. So what happened in Peacock? Juan? Sure.
So in Peacock, we have a builder of a condominium project, who is Peacock Construction Company, who's the subcontracts modern air conditioning, which is the guys who work on their heating and air conditioning, and Overly Manufacturing Company, which was working on a rooftop swimming pool in the condominium. In the written subcontracts, made final payment, or it provided that they would make final payment to the subcontractors by saying within 30 days of the completed work, included in the subcontract.
Yeah, I think you figured. Tell what page is that on? I don't have the page number, but everyone should have highlighted that provision.
It is on 854.
Page 854, right? And if you haven't highlight it now. Draw a little asterisk there, because when you're doing work on contract interpretation, you should read the contract. And this is the key provision that you need to read, so you should have highlighted it and thought about it. And it says, with the payment, it calls for payment from a contractor to a subcontractor, quote, within 30 days after completion of the subcontract work, written acceptance by architect, and full payment thereafter by owner. So let's interpret that just on its face, right? Let's begin by reading the plain language. That's the first thing we always do. We isolate the key language and we read it. What does this seem to say? Does this read like a condition? Does it read like a promise? Does it read like a conditional promise?
I think at first glance, it looks to me like, let's say, I want to say conditional promise, but I may be wrong.
What are some words in here? What does that word after do? I will pay you after I get paid. I will pay you after I get paid. That's basically what this said. Let's just simplify the language. So what does that mean to you? I will pay you after I get paid. I mean, Mary Beth, you were an actress, right? And so, did you ever have a situation where you were not going to get paid unless the show went on or was profitable? So did you expect? That's tradition. So let's explain that a little bit.
It's a condition of the show happening that you, because into a contract,
Right.
you get paid.
You get paid after the show happens. And if the show doesn't happen, Mary Beth doesn't get paid. You don't get paid unless the show happens. Right? Right, and so after, that's language that seems to indicate a condition here. It sounds like conditional. It doesn't say on condition of. It doesn't say that. But you get paid after I get paid. So that could be a condition. But, why you had an impulse, I think it's the right impulse, that you wanted to make this at least a conditional promise. Why is that? What's wrong with this being a pure condition?
Because if there's a pure condition, then
If this is a pure condition, then the contractor doesn't have to pay the subcontractor if the contractor doesn't get paid. Do you think that the subcontractor intended to take on that risk? What did the parties intend? Does a subcontractor who's doing a small piece of a giant job expect to take on a risk that the entire project will be approved by the owner? Is that the intention of the parties? Chris, shake your head no. Why is that not a reasonable expectation of their intentions?
No, well, the court kind of says they're like, I mean, the subcontractors, they need payment quicker to stay in business versus a general contractor where theoretically they would have more.
More projects, more funds, more assets, more capital, right? If this were understood to be a condition, what is the result? The result is if after means a condition, that means the general contractor does not have to pay the subcontractor unless and until the general contractor is paid by the owner. If this is merely understood as a promise, however, with an explanation of when this will be expected to pay, then there is an obligation, a duty to be paid, even if the contractor is never paid, still has to pay the sub. And the court here believes that this would be unfair, right? So does the court actually do any analysis of what the parties subjectively thought? Do we take testimony about what the parties thought? Or do we look at something else? The court actually decided this one is a matter of law. Right? The court decided this is a matter of law. Why is this a question of law? Well, the court here says that the contract lends itself to that judicial interpretation. Why? Well, this is how these relationships generally work. Again, we're looking at what is commercially reasonable under the circumstances. It would not be commercially reasonable that the subcontractor take on the risk in this case. That's not how we would usually think about that. So we're going to call this a promise and not a condition, because even though we have that word after, it doesn't say, it's not in the section entitled Conditions Precedent, and that's not what the parties would expect. We're trying to get in the minds of the parties, ascertain their intentions. And most likely the subcontractor did not intend to take on this risk. So what do we learn from this case? Well, we learned that sometimes the language of the contract will be overruled by a reasonable interpretation. Right? Even if a contract says one thing, or seems to say one thing, if it lends itself to another interpretation, courts will not always go with the plain meaning of the contract, where there are other considerations here. And I think the court here is making a policy judgment. The court is saying it would be unfair. Now, you know how I feel about those sort of things. It kind of cuts both ways. It takes away certainty from contracts. But in this case, this contract seemed to be ambiguous. You could see that the court could have framed this discussion in a number of ways. It could have also said, let's construe against the drafter. After is ambiguous. After is ambiguous. We have one very powerful party, right? A contractor that's building skyscrapers with rooftop pools, and very low power company, 3 guys with a van who do air conditioning repair. Right? Those 3 guys in the van doing the air conditioning repair versus the multi-billion-dollar contractor of huge skyscrapers, who is in the better position to take on risk? Who is in the better position to negotiate for terms? Who wrote the agreement? So there are several ways a court could have gone about this, but we have it in this section because the interpretation ties in to whether or not this is a condition or a promise. And finding here that this is a promise has the result that the contractor has to pay the subcontractor even if the subcontractor is not paid. So, I think you should, if you haven't already, take a look at this chart on here. I would suggest that you think about these cases, maybe try to flush them out a little bit. These are our 4 cases regarding express conditions. And I think that the categories here that you might want to think about in organizing your thoughts, you should think about what are the clauses at issue. I want you to always highlight, write down, think about the contract clause, because we have to read the contract first. Reading the contract would be the best evidence of what the parties thought and intended and probably get you to the right result, although not always. I want you to answer, did the court call us a promise, a condition, both, meaning a promissory condition, or neither? Right? We had examples of all the above. Think about why the court made that determination, because you'll have to do the same thing if presented this. You'll have to do that analysis. Right? You don't just skip to it. It says condition precedent, we're done. No, it's in the section condition precedent. But what does it say? What's commercially reasonable? What are the factors that the court will apply? Can you apply those factors? how does this affect the case's outcome? Meaning, what are the consequences of it being a promise, a condition, or a conditional promise? If it's a conditional promise, then failure for it to be performed, I'll start the other round, right? If it's a promise, my failure to perform a promise does not excuse Madison, but she can sue me. If it's a condition, my failure to perform excuses Madison, but she can waive it, but she can't sue me. If it's a promissory condition, my failure to perform excuses her, and she can sue me. Of course, whether or not she's going to have a fruitful suit depends on whether or not there were any actual damages. Was the clause performed? Did it actually occur or not? And, again, think about strict compliance. And as we got from our third case today, from Rena, time is of the essence when time is mentioned in an express condition. And then what legal obligations then does that create in the other party? I think that's the analytical framework that you would apply as you step through analysis of express conditions. And that will lead you to an understanding of whether or not the other party has to perform. And we're going to start discussing that after spring break. So we'll come back on Wednesday, and we're going to talk about our last section here, which is conditions of satisfaction. Right? Whether or not you need what you need to show to be satisfied. There's a reason this is still in the chapter on good faith, and then briefly discuss waiver, and then we'll be done with chapter 7.